request and how they respond. Mr. Soar, if you will, please open court.
The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon and welcome to the North Carolina Court of Appeals. I'm Judge Valerie Zachary. Serving with me on this panel are Judge Allegra Collins and Judge Toby Hampson. Assisting us today are Attorney Jean Soar with the Office of the Clerk of Court of Appeals and Ziad Hawk with the Supreme Court IT Department. We are live streaming this session of the Court of Appeals as we work remotely through the COVID-19 pandemic. Although we cannot currently invite members of the public to our courtroom in Raleigh, we are happy to welcome everyone to our virtual courtroom in the spirit of our tradition of publicly held proceedings. We have two cases on the calendar this morning before this panel, and these cases have been consolidated for hearing. We've got Wells Fargo Bank et al. Versus Orsbon and Fenninger LLP et al. And Jacob Samuel McElhaney et al. Versus Orsbon and Fenninger LLP et al. With the cases consolidated for hearing, argument will be a little different today. The appellants have 30 minutes to present their arguments and they're dividing their time. The appellees are dividing their argument time equally, 15 minutes apiece. If counsel are ready, let's proceed. Of course, the appellant will argue first.
Thank you, Your Honor. May it please the court, I'm Gary Parsons of the Wake County Bar. Appearing with me today is my partner, Kim Marston. We are pleased to be here representing Tony Orsbon and his law firm. The simple issue that you have before you, we would submit is that based on the evidence in the declaratory judgment action, the Superior Court held in December of 2018 that there was no question that Jane McElhaney, or as to Jane McElhaney's intent concerning her power of appointment when she executed her will and trust in December of 2015. The declaratory judgment court gave the judgment as a matter of law that Jane McElhaney did not intend to exercise that power of appointment. That resolves the core issue in the case against Tony Orsbon and his firm. If Jane McElhaney did not intend to exercise her power of appointment, her trust did what it was intended to do, and that is to leave her late husband's distributions unchanged and to cut some of the specific distributions from her personal trust, leaving others unchanged and adding $50,000 to go to her son's widow. I'll touch on the chronology very briefly, if it pleases the court. Sam and Jane McElhaney had updated their estate plans a number of times during the latter portion of their lives. Each had a pour-over will, and each had a revocable trust. Each trust, that is Sam's and Jane's, provided $2.75 million in specific bequests to a series of cousins, nephews, brothers, their church, which was to receive $700,000, and to various charities. None of these gifts would be made until the last to die of either Mr. or Ms. McElhaney. The survivor would be taken care of during their lives with trust income and distributions for support and maintenance and medical care. And then at the time of the last to die, the specific gifts from both trusts would be paid. And what was left, the residue, would go to the two grandchildren.
I'm going to jump in for a minute and ask a question.
Yes, ma'am.
So when we're talking about whether intent was actually litigated, Wells Fargo has a fiduciary duty to all of the beneficiaries, correct, in the declaratory judgment action?
Yes, ma'am.
So could it have taken a side as to what Jane's intent was, or was it simply asking the trial court to read the words on the paper and instruct Wells Fargo to disperse the funds as the words said?
Well, Judge Collins, I agree with you that Wells Fargo as trustee could not take a position. However, they were and are, by their own express pleading, in privity with the residuary beneficiaries, two grandchildren, who did very forcefully and very vigorously litigate the issue of James' intent. And collateral estoppel, as the court is aware, applies not just to parties to the prior action, but to those in privity with them.
So let me ask,
Yes, ma'am.
the privity, was that privity pled on this appeal of the medical malpractice? Did they claim to be in privity with the residual beneficiaries at the declaratory action stage?
They did, Your Honor. They specifically pled that they had been instructed by the grandchildren, the residuary beneficiaries, to file the malpractice action and that they were proceeding united with them.
I understand, but did they so claim at the declaratory judgment stage that they were in privity with the residuary beneficiaries?
I don't recall they did, Your Honor, but the whole point is, as a matter of law, they were in privity. And we've cited authority to the court in our brief that points out that a certiorari trust, which I'm sure I butchered because my Latin is far beyond remedial, is in privity with a trustee. And if a fiduciary litigates in a prior action, the trustee is going to be bound by that determination.
Well, if I may ask a question, the intent issue was argued in the reformation claim, if I understand correctly, right?
Yes, ma'am.
And the reformation claim was brought by the residuary beneficiaries?
Correct.
Okay, so how was the intent issue material to the reformation claim?
Well, a couple of things, Your Honor, and let me get right to it. The residuary beneficiaries counterclaim and cross-claim contained one count, and that was reformation to correct a mistake under GS 36C-4-14. Now, that statute provides that the court may reform the terms of a trust, even if unambiguous, to conform to the settlor's intention, if it is proved that both the settlor's intent and the terms of the trust were affected by a mistake of fact or law. That was an essential element of the claim that the residuary beneficiaries brought. They specifically alleged in their counterclaim in 1, 2, 3, 4, 5, 6 paragraphs that it was Jane McElhaney's intent to exercise the power of appointment, that the failure to exercise the power of appointment was contrary to her intent, that the failure to exercise the power of appointment was the result of a scrivener's error and did not and caused the terms of the trust not to conform to Jane's intent, and that the specific bequests that were duplicated in the two trusts were contrary to Jane's intent. All of those appear at the Rule 9 exhibits, page 330, 332, 333, at paragraphs 35, 44, 45, 46, 47, and 48.
But Mr.
Go ahead.
Don't you have to, in order to exercise the power of appointment, wouldn't you have to reform the will and the terms of which were unambiguous?
Yes, ma'am, you would. But the point is, they in fact litigated what her intent was. As we point out, they pled it, and then they submitted it for determination. Again, the elements of collateral estoppel are that it has to, well, as to whether the issue was presented or actually litigated, you have to have it properly raised in the pleadings or otherwise submitted for determination, and that it is in fact determined. Her intent was specifically pled repeatedly. it was submitted for determination because in seeking summary judgment, the specific beneficiaries, that is the cousins, the nephews, the nieces, the charities, specifically briefed whether Jane intended to exercise her power of appointment, whether any testimony existed to show that Jane intended to exercise her power of appointment, and whether the Wells Fargo representative, Linda Montgomery, the testimony from her created an issue of fact as to Jane's intent. Again, that appears in the briefs that are in the Rule 9 exhibits at 474 through 480. In resisting summary judgment, the grandchildren specifically briefed whether the evidence demonstrated an issue of fact as to whether Jane intended for her gifts in her amended trust to entirely supplant those in Sam's trust.
But I'm gonna jump in for a second. And
Yes, ma'am.
in order for collateral estoppel to apply, then the decision, it has to be immaterial, correct? And couldn't it have been that the trial court determined that there is no statute, there is no authority that allows reformation of a will to reform a trust? And let me say that another way. The statute that they went in under allows reformation of a trust, but it doesn't speak to reformation of a will. So couldn't the trial court have simply determined that there was no authority to reform the will in this case, and therefore her intent wasn't material?
Well, the issue that I would respectfully take with that, Judge Collins, is that Miller Building says that if there is no specific finding on a particular issue, the court can infer that a finding appropriate to the judgment that was entered is made as to every issue that was presented. Now, again, another critical difference between issue preclusion under collateral estoppel and claim preclusion under res judicata is that in issue preclusion, it doesn't even have to be the same claim as long as the issue is presented and decided. Here, there is no question in this record that the issue was pled. There is no question in this record, it's uncontradicted, that the issue was presented repeatedly and forcefully in the briefs and in the oral argument. There is no question it was decided because the court said in announcing its judgment, granting summary judgment to the other relatives and the charities, that the court found no issue of fact as to Jane's intent at the time she executed the instruments. So because of that, we have pled, presented, and decided. It doesn't have to be the same claim as long as it is the issue. And Jane's intent is all over the case in the declaratory judgment action. I think
Excuse me, does the court even have to get to, did the court even have to get to that? If they looked at the will and said the terms are unambiguous, and so we can't reform the will to include a power of appointment, then we don't even, then did the trial court even have to get to the issue of reforming the trust?
Well, Your Honor, I respectfully submit that that was the gravamen of the entire claim. And I would point out that if you look at the briefs that were submitted by both sides, everything they talked about was intent and what Jane's intent was. So a lot of what the appellees argue in this case is, well, the Superior Court might have done this and they might have done that, and they may have decided it in the exercise of discretion, and they might have not considered this. The difficulty is that we know exactly what the Superior Court said it did get to, and it said the issue of Jane's intent out of the court's own mouth in announcing its judgment.
So let me just follow up on that. There was obviously voluminous, I guess, argument on intent and evidence of intent, correct? And yet the trial court said there was no material issue, correct?
That's true, Your Honor.
And so they didn't resolve the issue of intent if there was a conflict, they simply didn't reach it. Or do you read that statement differently?
I read the statement differently, and again, with all respect in the world for my opponents, if you look at the face of the transcript and the actual words instead of what the court might have said, if we look at what the court did say, it said there is no issue of Jane's intent. And if you look at what the specific beneficiaries argued hard, both in the hearing and on paper, nobody talked about, or to any great degree, about materiality. I don't really think materiality appeared in the briefs in any significant way. What they argued as hard as they could go is the specific beneficiaries said, well, it's clear, it's uncontradicted that Jane didn't intend to exercise her power of appointment. The residuary beneficiaries argued the other way. Now, we can talk about whether or not the declaratory judgment court was correct when it found there was not an issue of fact. But the bottom line remains, the court did say what it said. And that is clear in black and white. That's why we had the transcript prepared. She made very clear that she found no issue of fact as to intent. So, to put it bluntly, the residuary beneficiaries lost, the specific beneficiaries won. The residuary beneficiaries had a chance to appeal that and to ask this court to find an error. They decided not to. They withdrew
Mr. Parsons, if I can jump in, just trying to put this in the context of legal malpractice claim. I'm just trying to figure out where the issue preclusion issue fits within that. You've got kind of this case within a case construct, right, in legal malpractice claims.
Yes, sir.
And so the declaratory judgment action certainly seems to go to that aspect of the case. But I guess I'm wondering that even with the resolution of that, is there still an issue as to sort of, elements such as breach of duty, or is your argument more that this sort of preclude you were entitled to summary judgment, based on an inability to prove damages because of the result of the declaratory judgment action?
Precisely, Your Honor. If there was no intent to exercise the power of appointment, there was no cause of any damage, because the instrument did what Jane McElhaney meant for it to do. That's it in a nutshell, Your Honor. You can argue all day long about whether he did or did not make a mistake. But if Jane intended to do what the declaratory judgment court ordered, i.e. to leave both trusts in place as they were, then there's no damage.
Mr. Parson, I think you've run out of time. I think you're into your colleague's time.
As a matter of fact, I'm catching an elbow right now. Thank you.
Okay.
Thank you, Judge Zachary. And may it please the court, I'm Kim Marston, and I want to address the election of remedies argument. The purpose of the election of remedies doctrine is to prevent redress for the same wrong. And that's exactly what happened here. The residual beneficiaries chose to pursue a cross and counterclaim to reform Jane's trust to correct a purported mistake. They then pursued this malpractice action to correct the same wrong, calling it negligence instead. The doctrine of election of remedies applies when there has been a final judgment or a plaintiff accepts the settlement and the remedy sought in the first action is inconsistent with the remedy sought in the second action. There's no question here that the residual beneficiaries lost at summary judgment, pursued an appeal, and then withdrew that appeal by accepting a settlement agreement to resolve the declaratory judgment action and the reformation claim. So the question here is an attempt to reform Jane's trust consistent with an attempt to gain damages for the alleged negligent drafting? They are inconsistent. It does not matter under McCabe that the amount that the plaintiff requested is not what they got. And as our Supreme Court noted in Pete Wall cited in our brief, it does not matter if the judgment or decree is for or against plaintiff. What matters is that there was a final and definitive election to pursue an inconsistent remedy.
So let me ask, we've got two parties here. We've got Wells Fargo, and I'm going to call them residual beneficiaries because I can't say residuary beneficiaries. So the residuary beneficiaries came to a settlement, correct?
Wells Fargo was also a party to that settlement, Your Honor.
They were party to the settlement, and their choice was that they would be taking attorney's fees out of the trust and not otherwise, correct?
That is correct. The settlement did authorize that.
Okay, so was there more for Wells Fargo? They are considered a party to that settlement?
They are a party to that agreement, yes.
Okay, so my next question is that you all initially pled standing and then did not argue that at the trial court. Why didn't you argue standing as regarding the residual beneficiaries?
Your Honor, for the residual beneficiaries, they have an interest under malpractice claim as a potential beneficiary, third-party beneficiary to the attorney-client relationship, and so we did not pursue the standing argument. But it is clear, and both of the plaintiffs in both cases recognize that they cannot both recover damages. In both malpractice actions, the only damage that would actually be owed would be $2.75 million, which is the damages that they claim. And so the question is whether the remedy sought for the reformation addresses the same wrong and whether it addresses the same damages. A remedy can be inconsistent when it's a continuation of the relief sought in the first action, or it can redress the same damages. And here, the damages alleged in the reformation claim was that the documents did not match Jane's intent, and therefore there was less money left in the residual to go to the residuary beneficiaries. Those same damages are claimed here, that there was less money left over in the trust to go to the residual beneficiaries. Now, the plaintiffs argue that the reformation claim only dealt with the trust and that this claim, this malpractice claim, deals with the will because they could not seek to reform the will. But that misses the point. The fact that they couldn't be made whole, in their words, does not matter for the election of remedies doctrine to apply. As our Supreme Court noted in Pete Wall, even if a plaintiff fails to secure full satisfaction by means of the remedy adopted, the election of remedies doctrine applies. This case fits with the cases that squarely hold that a plaintiff cannot seek to rescind or reform an agreement and at the same time affirm that agreement as written and pursue damages. And
let me ask a hypothetical. If the only action before the trial court had been Wells Fargo's declaratory judgment action, and it had directed Wells Fargo to disperse the funds as written as it did, would there now be a legitimate malpractice claim? Would it now allowed to be continued?
Well, and Your Honor is referring to the McCabe case. And in the McCabe case, this court said, yes, an executor who pursues a declaratory judgment action to obtain clarification of a will can then seek damages solely, but the only damages that were at issue there were the attorney's fees in the declaratory action. There was no claim for reformation in the declaratory action in McCabe, and so there was nothing that was inconsistent with the damages that are sought in the subsequent malpractice action.
So McCabe obviously only reached the issue of attorney's fees, right? So McCabe didn't reach any other issues. So we don't really know, based on McCabe, whether this would go forward.
Your Honor, that case doesn't help us. And so we have to look at other election of remedies cases when we're looking at the question of the $2.75 million in damages that are alleged that didn't stay in the trust to eventually flow to the residual beneficiaries. And those are the cases that talk about rescinding or affirming. And those are the cases that also talk about attorney malpractice. And although they don't have to have obtained the remedy, it's helpful in terms of the rescind or sue for damages analysis to consider what would have happened had they won the reformation claim. They would have eliminated all of the bequests from Jane's trust. They would have, in other words, saved $1.05 million for the trust to flow to the residual beneficiaries. If they then pursued this malpractice action and won $2.75 million, which is the damages that they allege were distributed from Sam's trust because Jane's will didn't get rid of those, the end result of both of those claims would be that the residuary beneficiaries have a net positive of $3.8 million. That's everything. That would essentially mean that nothing was given out to any other individual or charity. Essentially, it means that the plaintiffs would recover more than the damages they're actually seeking here or that they're entitled to. And that is the essence of a double recovery.
Ms. Marston, if you would just briefly, will you discuss the significance of the fact that the parties reached a settlement in the underlying action?
Absolutely, Your Honor. The cases consistently hold, and these are cited in our brief, that it's either a final judgment, pursuing a final judgment all the way to final judgment, or accepting a settlement that is the final definitive election that bars them. Had they not settled that claim, had that claim still been on their appeal from the court's summary judgment order dismissing their reformation claim, we wouldn't have this election of remedies defense. That settlement agreement, bringing finality to it, accepting what they accepted, was their election of remedies. And that case comes up and it is addressed in several of the malpractice cases that deal with the election of remedies. And this malpractice case fits most squarely into Stewart versus Herring. There, the plaintiff had an alimony action against her husband, and she alleged that the defendant attorney committed malpractice in having her enter a separation agreement that released her claim for permanent alimony. Instead of going and immediately pursuing her claim for malpractice against the defendant attorney, she initiated the first action in that case, which was a divorce action brought by her husband, where she counterclaimed, just as the residuary beneficiaries did here, she counterclaimed to set aside that separation agreement. She ultimately settled that claim. They rescinded the first separation agreement and they entered a new one. But she claimed that she still had lost some money because of the negligence and pursued the negligence claim. And this court, addressing her argument that that was merely a mitigation of damages, denied that and held that it was bound by North Carolina case law that she had finally and fully elected her remedy about the separation agreement and about alimony by pursuing the alimony action, rescinding the agreement, and ultimately settling it. As I mentioned, the McCabe case only applies to the Wells Fargo claim for attorney's fees. It does not apply to the $2.75 million in damages that is being sought. Wells Fargo has brought a claim not just for their attorney's fees, they've also brought the identical claim to pursue the damages. And the plaintiffs cannot get around the election of remedies bar by changing the nominal plaintiff. As Mr. Parsons mentioned, Wells Fargo has alleged here that they are in unity with the residual beneficiaries. The damages awarded from either of these cases will flow into the trust and ultimately to the residual beneficiaries. Because they have made a final election of a remedy, both Wells Fargo and the residual beneficiaries should be barred. We'll reserve the rest of our time. Thank you.
Thank you both. Mr. McPherson, yeah, you may proceed.
Good morning, Your Honors, and may it please the court. My name is Rich McPherson with McGuire Woods from the Mecklenburg County Bar. I will be addressing the election of remedies argument, and Stephanie Daniel, counsel for the residuary beneficiaries, will be addressing the collateral estoppel argument today. Your Honor, the doctrine of election remedies does not apply to this case because first, there is no substantial right to an interlocutory appeal of a summary judgment order of an election of remedies defense. There is no case law supporting this appeal. Turning to the merits, there are two elements of an elections of remedies doctrine. First, were all of the plaintiffs, and here you have to look at each of the plaintiffs, did they elect a remedy and was it a final judgment in the first action? And the second element, is that remedy that was elected in the first action consistent with the remedies that are now sought in the second action? It's important to look carefully at who the parties were and what remedies did they elect in each action. Turning to the first element of the election of remedies doctrine, looking at what remedies were elected in the first action, the declaratory judgment action, and did those go to a final judgment? Here, there are 5 plaintiffs. Wells Fargo is the executor of Jane's estate. Wells Fargo is the executor of Sam's estate. Wells Fargo as the trustee for Sam's trust, and Wells Fargo as the trustee for Jane's trust, and 2 residuary beneficiaries. In the declaratory judgment action, 2 of the Wells Fargo entities, Wells Fargo as the executor for Jane's trust and Wells Fargo as the trustee for Sam's trust, were not a party to the declaratory judgment action. The only party to that action was Wells Fargo as the trustee of Jane's trust. The remedy that Wells Fargo as the trustee of Jane's trust sought in that action was a declaratory judgment claim seeking clarification of a latent ambiguity in the will and trust. That was the only remedy that was sought there. The residuary beneficiaries brought a claim for reformation of Jane's trust. They did not bring any claim related to Jane's will. So for Wells Fargo, 2 of the entities did not were not a party to the case and couldn't have elected a remedy in the case. For the third Wells Fargo entity, Wells Fargo as the trustee for Jane's trust, they only brought a declaratory judgment claim, and as McCabe hold, that is not inconsistent with a legal malpractice claim. Turning to the second element, whether the remedies sought in the declaratory judgment action are consistent with the remedies sought in the legal malpractice action, again, it's important to analyze the claim from the perspective of each plaintiff. 2 of the plaintiffs did not participate in the action and couldn't have elected a remedy. The third plaintiff, Wells Fargo, as trustee for Jane's trust, participated but only brought a declaratory judgment claim, which is entirely consistent with that legal malpractice claim. The declaratory judgment claim simply asks the court to construe the terms of Jane's will and trust, which had a latent ambiguity in it. And
so let me jump in. Was Wells Fargo, any of these Wells Fargos, were they parties to the, I guess I'm losing my word, were they party to the settlement of the reformation claim?
Wells Fargo as the trustee for the 2 trusts were parties to the settlement agreement, but they did not, that doesn't impact the election of remedies analysis because it doesn't impact what remedies they elected. They were parties to that because those trusts were paying out part of the settlement agreement. But the only party, they were signatories to the settlement agreement, but the only party to the declaratory judgment claim was Wells Fargo as trustee for Jane McElhaney's trust. And Your Honors, I think it's important to note that as looking at these entities separately, the declaratory judgment action was entirely consistent with the remedy that's being sought now. In the declaratory judgment action, Wells Fargo as trustee for Jane's trust was simply asking the court to construe what it determined was a latent ambiguity in the will and provide guidance on how to pay out here. In this case, Wells Fargo as trustee for Jane's trust, as trustee for Sam's trust, which was not a party to the declaratory judgment action, and Wells Fargo as executor of Jenny's estate, is bringing a claim for legal malpractice based on negligence in drafting a will, and that's a separate document from the trust. So not only for the election of remedies is it important to look at the separate parties that were plaintiffs, it's also important to look at the separate documents that were here and was an election of remedies made as to those documents. So for two of the Wells Fargo entities, they weren't a party, they couldn't have elected a remedy. For the third Wells Fargo entity, Wells Fargo as trustee for Jane's Trust, it elected a remedy that was entirely consistent with a legal malpractice claim, because in the declaratory judgment claim, it simply asked the court for guidance on how to interpret a document. And then in this case, it is now seeking relief for legal malpractice based on negligent drafting.
Actually,
As for the residuary,
if I can jump in, can you articulate for me the damages that remain following the declaratory judgment action that you allege remain to the Wells Fargo represented entities in this case?
yes, Your Honor, the damages in this case are $2.75 million in damages based on negligent drafting of Jenny's will. Had the will been drafted properly and exercised the limited power of appointment, and that would have been done in Jenny's will, Ms. McElhaney would have replaced the $2.75 million of gifts, and that is the damages that we're here seeking today, because those damages were paid out because of the will being drafted negligently. Turning to the residuary beneficiaries, and before I get to them, Your Honors, it's clear that from counsel's argument that the only way they believe that the Wells Fargo entities could have elected a remedy is to build a bridge between the Wells Fargo entities and the residuary beneficiaries. And the way they attempt to build that bridge is through a doctrine of privity. That doctrine of privity was not present in the declaratory judgment action first. So the declaratory judgment action, there was the declaratory judgment claim brought by the trustee of Jane's Trust, and no privity was alleged. In fact, different claims were made. In this action, there's, again, no privity alleged and no case law that's cited that says a trustee and a beneficiary of a trust are somehow in privity. The fact that the trustee of Jenny's Trust, the trustee of Sam's Trust, and the executor of Jenny's estate are now all bringing similar claims to what's being brought by the residuary beneficiaries shows that they're all pursuing the same claims. It does not create the legal concept of privity between a residuary beneficiary and a trustee. And in fact, there's no support for that. So even on their best day, because there's no privity here, they can only argue election of remedies as to the residuary beneficiaries, and that would not in the case. And that's another reason interlocutory appeals on election of remedies like this one are not appropriate. But even if you looked at the residuary beneficiaries, they also didn't elect a remedy that's inconsistent with what's being sought in this case. The residuary beneficiaries were seeking to reform Jenny's trust. They weren't seeking to reform a will because there's no way to reform a will under North Carolina law. So they elected a remedy related to a different legal document, and that was final. There's no question about that. But the question is whether it's consistent, and it is consistent because it's a different document than what is being alleged here was done negligently. What was alleged that was done negligently here was the drafting of Jenny's will, and therefore the doctrine of election of remedies doesn't bar the residuary beneficiaries claim either. And I do want to address one point that was made in opposing counsel's argument about election of remedies barring harm for the same wrong. And that's not the case, and McCabe clearly shows that. In McCabe, there was the declaratory judgment action, all related to the same issue of an ambiguity in an estate planning document, and a legal malpractice claim that followed. And yes, it was for attorney's fees, but it was a different, procedural situation. But McCabe makes clear that election of remedies is not about the redressing the same wrong. It's about whether the remedies are consistent. And here, Wells Fargo, two entities didn't elect an inconsistent remedy because they didn't participate in the first action. The third elected a consistent remedy because McCabe holds you can file a declaratory judgment action and then a legal malpractice action. And the residuary beneficiaries didn't elect an inconsistent remedy because they first sought to reform a trust and later brought a legal malpractice claim related to a will.
But didn't they actually, the residuary beneficiaries, and then if you feel like Wells Fargo is in privity with them, then Wells Fargo as well, weren't they actually seeking the same remedy? Either through
No.
reformation or through the civil damages?
No, Your Honor, they couldn't have sought the same remedy in the trust reformation action. The trust reformation action was only seeking to reform the $1.05 million gift to make sure that was as closely as possible to match Jenny's intent. Here in this case, the remedy, the amount in damages that is being sought is that $2.75 million that comes from Sam's Trust. So they're seeking remedies that are entirely consistent.
I'm confused. I feel like both actions were going after the same $2.75 million. Explain to me again how I messed up the math.
Yes, Your Honor. Under the trust reformation statute, the residuary beneficiaries, again, Wells Fargo brought merely a declaratory judgment claim, was not seeking monetary relief. The residuary beneficiaries were only seeking to change the 2015 trust, which had granted $1.05 million in gifts, and that's different from the $2.75 million in gifts that were supposed to come, that were originally supposed to come from Sam's Trust. And so it couldn't have the, and this is an important point, and counsel for the residuary beneficiaries may also be able to make this, but as the residuary beneficiaries, they could only reform Jane's trust. They couldn't have reformed Sam's trust, and that's where the separation occurs. And you're an honor. If there are no other questions about election or remedies, I'll defer the rest of my time to counsel.
I have a question.
Yes, Your Honor.
So they never sought to reform the will?
No, Your Honor. There is no legal, that's an important point. There's no legal authority in North Carolina that would allow them to reform the will. The only reformation statute under North Carolina law is a trust reformation statute and not a will reformation statute. So they couldn't have reformed the language in the will to change Jenny's exercise of the limited power of appointment. The best they could do in that case was seeking to reform the trust, which was the gift that was made in 2017 for $1.05 million.
And it's your contention that if you choose this remedy, knowing that you won't get as much with this remedy as you would with this other remedy, then you can still pursue the second remedy. You're not precluded from the second remedy if the first remedy doesn't make you whole.
Yeah, the residuary beneficiaries could choose to bring the trust reformation claim because they're seeking to reform the trust and they couldn't have authority to touch the will, and that's why these remedies are consistent as to the residuary beneficiaries.
Okay.
Thank you, Your Honors.
Do y'all have any further questions, Judge Collins, Judge Hampson? Thank you.
Good morning, may it please the court. I'm Stephanie Daniel from the Mecklenburg County Bar representing the plaintiffs, Jacob and Julie McElhaney, and I'll be addressing the issue of collateral estoppel for all the plaintiffs in this matter. The issues before your honors today relate, as you've heard, relate not only to an attorney malpractice claim filed by the appellees, but also to the prior action for declaratory judgment seeking to construe the terms of Jenny McElhaney's trust following her death. The DEC action was initiated by the trustee of Jenny's revocable trust and asked the court to construe that document to determine whether language in that trust constituted Jenny's exercise of a power of appointment. A power of appointment is a tool that is used by one person to select a second person who is given permission to change the disposition of property in the first person's will or trust. In this case, Sam McElhaney had given his wife Jenny, who is also referred to as Jane, but I always call her Jenny, the permission to change the gifts set out in Sam's revocable trust. To exercise this power, Jenny was required to include a specific provision in her will referencing this power and then listing the changes that she wanted to make. It is apparent that the required language was not included in Jenny's will. However, given some questionable language in Jenny's trust, the declaratory judgment action was filed asking the court to determine whether that questionable language qualified as an exercise of the power of appointment. The plain language of Jenny's will clearly did not exercise the power of appointment.
I just have a question. I have a question that is definitely was meant for the trial court, but I'm going to ask it anyway. So why bring a declaratory judgment action to determine if language in a trust did what only language in a will could do?
Because, Your Honor, in North Carolina, we have a substantial compliance statute. And the statute says that the power of appointment can be exercised in another form if it substantially complies. And so that was one of the issues that Wells Fargo, as the trustee of Jenny's trust, was running into. They needed the court to determine whether the language that was questionable, that they found questionable in the revocable trust document, complied with that substantial compliance statute. So they were asking the court to make that
even if
determination.
language, even if Sam said this has to be in a will, it was possible due to substantial compliance that it didn't have to be in the will. It could be in the trust.
Right, that's what that substantial compliance statute focuses on, is if someone tended to exercise the power of appointment and they substantially complied, then that could be construed as an exercise of the power of appointment, even though that language did not appear in this case, in Jenny's will.
So it actually is, I guess, conceivable that you could bring a reformation claim to the trust to bring that trust in substantial compliance somehow, such that the terms actually do get reformed.
Your Honor, I don't think I think that's trying to compound two statutes upon one, and I don't think that would be available relief. I think that the language itself has to, of the document, has to comply. It has to exercise. So for example, if the trust document had a provision that said exercise of the power of appointment, and then listed that exercise, that the way the power of appointment was to be exercised, I think that would substantially comply. I don't think that the trust reformation statutes would allow the trust to be reformed to include that language.
Why not? Why not?
I don't think there's any precedent for that situation. And I think that, the substantial compliance statute itself looks at the language that is there, the plain language that is there, not reformed language to try to get it to that point.
So if the trust substantially complies, but it needs to be reformed, maybe just a little bit, needs to be tweaked a little bit to make it reform to the settler's intent, then that's an available remedy. Is that what
I
you're
ju-
saying?
Well, I don't think so. I think that's a little bit of an overreach. For example, as an estate planning practitioner, how the exercise of a power of appointment would normally appear would be a separate provision, an article in the individual's will. If that exact same language that should have been included in the will was included instead in a revocable trust, I think that's when the substantial compliance statute would apply. And so then the trustee would say, does this, even though it's in like Sam's trust required it to be in the will, but it was in Jenny's trust, does this language substantially comply so that the power of appointment was effectively exercised? I think that's that situation. I don't think that the court could reform the trust to add that language and then apply the substantial
Right.
compliance statute.
Right, in this case, but if there was substantial compliance, where would intent come into that then? Where would
I don't think
Jenny's
intent is in that analysis, Your Honor.
Okay, so her intent would be immaterial, except for the fact that apparently she wanted, in the example that we're using, apparently she wanted to exercise the power of appointment.
Correct. In the question, in the hypothetical you've asked me, her intent doesn't come into play at all because the language is there. Her intent doesn't need to be construed because it is there.
Mm-hmm.
If the provision had been included in the revocable trust, intent only comes into play in regards to the current situation because the language of the trust did not match her stated intent.
Mm-hmm.
And so the trust reformation statute is what opens the door for the settlor's intent to be examined.
So intent was a material issue in the trust reformation action.
It would have been, Your Honor, had the court gotten to that analysis. However, the court determined that that relief was not available. So they didn't get to the analysis of what Jenny's intent was. They determined that the relief was not available, that claim was not an available claim to the residual beneficiaries. And as a result, they never even got to the point of examining what Jenny's intent was. Had the trial court determined that the trust reformation was an available claim, then they would have looked at Jenny's intent. So because they didn't make it to that analysis, her intent was immaterial in regards to the trial court's decision in the declaratory judgment action.
Can you point to language where the trial court specifically said, what I think we're all dancing around is that there's a statute that allows for reformation of a trust, but there's nothing that allows for reformation of a will. And therefore, intent is immaterial.
Well, in regards to that issue, Your Honor, the transcript is replete with examples of where the movements in the motion for summary judgment argued just that. If I can share my screen, I will.
Yeah, and I know it was argued. I'm just looking for language from the trial court that says that that's what it's determining.
Well, the trial court's language, unfortunately, was very limited in nature and limited in scope. In regards to the trial court's ruling, she said that she did not find any issues of material fact as it related to the issue of intent. So because evidence was produced by both parties in regards to intent, for her to make the decision that she made on the motion for summary judgment and the fact that she ruled on the summary judgment, the inference is there that the trial court ruled that those issues were immaterial. And so as we examine the issue of collateral estoppel in this case, the trial court found that the defendants did not and could not meet the necessary elements of the defense of collateral estoppel and correctly concluded that that defense was not appropriate. As has been discussed, North Carolina courts have defined the elements of collateral estoppel as follows. The issues must be identical to those involved in the prior litigation. The issues must have been raised and actually litigated in the prior litigation. The issues must be material and relevant, and the issues have been necessary and essential to the trial court's ruling in the prior litigation. So first, an examination of the two cases reveals that the issues raised in the two cases are not identical. The issues raised in the DEC action are whether Jenny exercised the power of appointment in her will, whether the questionable language in Jenny's trust could be considered an exercise of that power of appointment, and whether Jenny's trust could be reformed to remove the specific gifts in her trust to match her intent that only one set of gifts be made.
I want to ask a question. So we've got that statement there that there is no material issue of fact regarding Jenny's intent, correct? That was stated.
Correct.
Okay. It seems like we could construe that two ways. One of the ways is that although there was copious evidence of intent, the trial court didn't need to consider it because it wasn't material. The other way to consider it is, as your friends on the other side would say, that there was no material issue of fact and that the intent was clear and that this is exactly how she intended these documents to be drafted. If it's ambiguous, if that statement is ambiguous, what do we do with that? Where does that play out in terms of standard of review or anything else that we're doing?
And Your Honor, I think that you have to look at the other statements made by the court, the trial court, and the declaratory judgment action. The court went on to say, even though she didn't say very much, she went on to say that the claim for reformation was not available. And so if the claim itself was not available, you don't get to the next step of determining what intent was. So because the claim itself was not available, any issue of intent therefore became immaterial. And so looking back at the issues raised in the malpractice action, those issues were whether Jenny actually intended to exercise the power of appointment, whether she communicated that intent to Mr. Orsbon, and whether Mr. Orsbon failed to properly draft Jenny's will and trust in accordance with Jenny's instructions. So as you can see, these issues are far from identical. In fact, the only issue the appellants argue is identical is this issue of intent. Due to the fact that neither Jenny's will nor Jenny's trust could be reformed to exercise the power of appointment, any examination of Jenny's intent was limited to the request to reform the terms of the trust to her intention. As the trial court found this request did not constitute an available claim for relief, Jenny's intent on this and any other issue was immaterial. Second, for the defense of collateral estoppel to apply, the issues must have been material. Although the appellants assert in their briefs that neither side in the DEC action took the position that Jenny's intent was material, the movements in the summary judgment motion did just that. Ms. Kirk argued that the trial court didn't even have to make a call regarding Jenny's intent because the motion before the court was a dispositive motion and there was no admissible evidence to show what Jenny's intent was. Both attorneys representing the movements, Ms. Kirk and Mr. Hudson, argued that the case of Britt v. Upchurch prevented the court from even considering Jenny's intent. Ms. Kirk argued that there was no substantive evidence of Jenny's intent in the DEC action and that all evidence of intent went to the credibility of Mr. Orsbon as a witness. Mr. Hudson argued that there was no issue of fact for the trial court to consider because the only document that could be reformed to exercise the power of appointment in was Jenny's will, and the law precluded that remedy. Both attorneys argued repeatedly that the judgment should be had as a matter of law and that the remedy requested in the reformation claim was not available. Third, the issue must have been necessary and essential. There are no findings in the trial court's order regarding Jenny's intent. When announcing its ruling, the trial court concluded, as we have discussed, that Jenny's intent was immaterial. The trial court's decision followed the arguments of counsel for the movements and that there were no issues of fact for the trial court to consider because the relief sought in the reformation claim was not available. Additionally, if the trial court had found the issue of Jenny's intent was necessary and essential, it could not have made a decision regarding Jenny's intent on a motion for summary judgment. as the parties had offered conflicting evidence of Jenny's intent. Thus, the correct inference for the trial court's decision is that the disputed issue of fact, Jenny's intent, was not necessary or essential to its ruling. And so I see my time is almost up. I want to make sure if
No,
anyone
your
see if
time
anyone has any
is up.
questions. Oh, it is up. I'm going the other way. Sorry about that.
Judge Collins, do you have any further questions? Judge Hampson?
No, thank you.
Okay, all right. Thank you very much. We can proceed with rebuttal.
I want to do a little bit of a sprint, if I may. So first of all, it's a little late in the day for Wells Fargo to be arguing privity. I word searched their brief in getting ready for oral argument. The word privity does not appear in it. They did not oppose it. They did not challenge it. They did not argue in response to it. With good reason, because if you look at record page 4, the complaint in the malpractice action, they specifically plead at paragraph 6 that Jacob and Julia McElhaney have instructed the trustee to proceed with this malpractice claim, and they are united in interest with the trustee. Now, also Wells Fargo said that we did not cite a case on privity with the trustee in our brief. I would respectfully invite the court's attention to page 25 of our appellant's brief. In the Wells Fargo case, at footnote 4, we cite to settle through Sullivan versus Beasley, a 1983 Supreme Court decision that characterizes the concurrent relationship, i.e. privity. It can exist between a guardian and ward or trustee and beneficiary. I will say we scoured North Carolina hard looking for something more specific, and we could not find anything other than amateur second. And I would respectfully submit that's because nobody had really thought to deny privity between a trustee and a beneficiary. The issue of intent, Your Honor, whether it was presented or not, I would respectfully invite the court's attention to the Rule 9 exhibits, the conclusion of the residuary beneficiary's brief in the deck action at page 412. Because the evidence shows that Jenny intended to exercise the power of appointment to reduce or eliminate the specific bequest, such determination can be made as a matter of law, and they asked the court to grant summary judgment to them instead of to the specific beneficiaries. The specific beneficiaries' brief conclusion at Rule 9 exhibits 482. All competent evidence indicates that at the time she executed her trust and will in 2015, Jane did not intend to exercise her power of appointment. Thus, the court should hold as a matter of law that Jane did not exercise her power of appointment. The testimony regarding the present intent indicated that Jane had no intention of exercising her limited power of appointment. Finally, the argument that the judge, Judge Edie Williams found that the issue of Jane's intent was immaterial. Exactly quite the opposite was true, because what Judge Edie Williams said completely is that I'm finding that Jane did not exercise her testamentary power of appointment in either her will or her trust, and that the claim for reformation will not be available based on the evidence of her intent at the time of execution. That appears in page 505 of the Rule 9 exhibits. So what does not appear is at no point does Judge Edie Williams say that intent was immaterial. Rather, she specifically said, I have looked at the evidence of intent and I find that based on what is there, I see no issue of fact on what her intent was. Now, the plaintiffs also referred to the substantial compliance statute. Again, a reason that this was clearly an issue in the DEC action is because the substantial compliance statute 31D-3-304 cited by the residuary beneficiaries in page 411 in their at page 411 of the Rule 9 exhibits quotes the statute that says the that a power holder's substantial compliance with a power of appointment imposed by the donor is sufficient if, a power holder that substantial compliance with exercise is available if both of the following apply: the power holder knows of and intends to exercise the power. All right. As far as whether intention was argued vigorously, Your Honor, in the transcript of the DJ hearing at Rule 9 Exhibits 485 and 505, the word intent or intention appears 53 times. I gotta say, if it's not material, I don't know why they talked about it so much. So, yeah, I'm out. I'm sorry, it looks like I've hit the wall.
You have. Thank you very much. Do we have any questions, any further questions, Judge Collins, Judge Hampson? Thank you.
May I apologize for blowing through the stop sign? I'm sorry.
You know what? I was engrossed in what you were saying and didn't even notice. So I apologize as well. It's kind of my job to keep up with it.
Thank you for your patience.
This is an interesting case, a very interesting case. All right, that concludes oral argument in this matter. Thank you, counsel, for your participation in our WebEx oral arguments today. They're excellent oral arguments, and we've got much to consider.
Thank you, Your Honors.
Thank you, Your Honor.
This session of the North Carolina Court of Appeals is now adjourned.
Please.